So hi everyone, hi all the participants and the speakers. Now we are having our next discussion, that is a quick, knowledgeable and intriguing discussion on the patent protections for software implemented inventions. We have our speakers joining in here, Andrey Inshakov, Head of Patent Department, Yandex. We have Gaurav Phadnis, he's a attorney from Bajaj Electricals Limited. We have Martin Schweiger, Managing Director, Schweiger Partners, and the moderator for the session, Sean Harte, Director Intellectual Property with Eaton Intelligent Power Limited. So over to you, Sean.
Thanks, Ankit. I think maybe if each of us gives a slight introduction to ourselves, that will probably ease us into the session quite nicely. My background is that I am a software patent attorney of over 20 years experience. I've worked for a number of US multinationals and in private practice. I'm currently the Global Director of Intellectual Property for Eaton, who are a power management company who are very rapidly transitioning to be an intelligent power management company. So software is obviously key to our product lines. Andrey, perhaps you'd like to give some background to yourself and your company.
Sure, thank you. My name is Andrey Inshakov. I am a Russian patent attorney, a patent and trademark attorney, and I lead all patent efforts at Yandex. Yandex is the largest internet company in the post-Soviet area. We have various services. The main one is internet search. We also have audio and video streaming services, cloud platforms. We have a taxi service similar to Uber, and many other products. So most of the patent applications that we file are related to software.
Thanks. Gaurav, if you'd like to just give a few words about yourself and your company.
Sure. Thank you, Sean. So my name is Gaurav Phadnis, and I am, as you know, I am the Chief Intellectual Property Attorney with Bajaj Electricals Limited at present. So we are a consumer durables company, and we manufacture products that are related to illumination products, and also home appliances, kitchen products. So these are our main line of products, and which we cater to our domestic market also as well as internationally. So I am an Indian patent agent and a trademark attorney. I come from a practice-oriented experience, and I've just about one and a half year back shifted to in-house. So that is my brief background. Thank you.
Thank you. Martin, I think anyone that was on before and saw your excellent presentation on the 7 golden rules for software patenting will be very familiar with you. And I have to say, I really enjoyed that. I thought it was excellent. But if you'd like to give us some background about yourself and your company, that would be perfect.
Okay. Yeah, I'm a German, Singapore, and European patent attorney since 1993, which is 28 years this year. And I've set up my firm, Schweiger and Partners, 1996, and I run it since then. I'm a robotics engineer by training, and I became a patent attorney only because I had so many inventions and I wanted to find out how I could protect it. And then I decided to switch sides and help people with their inventions because that is somehow more sustainable than being an inventor. I have drafted myself more than 500 patents in my lifetime, prosecuted 18,000 with my firm over the past 25 years. And yeah, one of the things I get really passionate about, and probably you have seen that, is software patents, because this is where everything started with my own invention for a sensor for the robot arm of the space shuttle back in 1991. And yeah, so I worked for a subsidiary of NASA at that time, and I'm really honored to be with power boys from the internet era. And Yandex is quite impressive. Also, you, Sean, with your company. I made a statement, right, that made you jumping. There is no artificial intelligence, and there will never be one. And yeah, I'm already looking forward to that fight that develops now. Gaurav, also you, very impressive. I'm looking forward to have a very nice discussion. And being a contrarian, I'm a contrarian by nature. I will take whatever other position that you take, whatever, and then let's see where we go.
That would be very encouraging experience, you can say.
Yeah.
Thanks, Martin. I think the first thing I'd like to say is that software patenting is such a vast area with so many aspects that we've decided not to propose to try and address them all, because frankly we could be here all day and all night, and it sounds like with Martin on the panel it would be all day, all night and all tomorrow. So I think we've just decided to address 3 or 4 areas in a bit more detail rather than just touch on everything. And I think we've had some good discussions around AI already earlier on today. But I think from Andrey's experience, you know, with a search engine and Yandex, it seems really important to you. And as AI becomes more and more prevalent in patents application, I was wondering what you think the most effective way is that you can actually go about patenting AI-based inventions. Notice, Martin, I didn't say AI inventions, I said AI-based inventions.
Ah, so you withdraw already, right?
Well, I never put myself forward.
Hey, there's somebody calling on Skype. I need to click this guy away. Please forgive me for the noise that there is on the. Please forgive me. I tried to send them a. Yeah, okay, but I point taken. So I'm 1-1-1-0 in advance, right?
Andrey.
Yes, thank you, Sean. Thank you very much. This is a very good question. Indeed, the patenting of AI-related inventions is booming now. We can see it in the registries of patent offices. We see that many companies are filing AI-related patent applications, and even in the areas that are not traditionally associated with software, like healthcare, for example, or heavy industry, like oil refining and so on. So AI is everywhere now. And we also can see that from the activities of the patent offices. For example, a couple of years ago, World International Patent Organization published a huge research. It's about 160 pages long, about AI and the technology in general and AI-related patents. And a similar publication was made by the UK Patent Office, and also European Patent Office issued new examination guidelines related to AI inventions. So the area is booming, as I've said. And as to the question of how to protect AI-related inventions, here's what I think. I think that most of the AI-related inventions are hidden into, they actually follow a similar template. So each AI-related technology has 3 areas where the invention may be hidden. The first area is everything related with training and training data. The other one is the machine learning system, which is basically several, one or more software modules that communicate together, that work together, and one of them is one or more of those modules are actually AI. Let's say a neural network or decision tree based algorithm. And the third area is the application. Sometimes even when you apply a new method, a known neural network to some new area, let's say weather prediction. We used same technologies that we use in internet search to weather prediction, to even to the heavy industry processes. So when those 2 worlds meet, this is where the invention may be hidden. And briefly, I will say about each of those areas. The first one, training. Basically, for training an AI system, you need a lot of data. And there can be techniques how to assemble this data and how to mark it, how to label it, to teach the machine learning algorithm which one is right, which one is wrong, how to answer the question you're asking it. So there can be methods of generating the training set. It can be automatic or semi-automatic, and methods to labeling this data. Also, there can be interesting techniques of how actually to train the machine learning algorithm. The process of training can be unique. And also, when you're using your training data, some of the training features can be unique and can also be patented. As to the second part, the machine learning system, well, the core of the machine learning system is basically a machine learning algorithm, but this is not the only place where the invention can be hidden. You don't have to necessarily invent a new architecture of a neural network. There can be things around that neural network or decision tree-based algorithm that can be patented. For example, there can be several algorithms that are trained together or communicate with each other. For example, the outputs of one algorithm can be used as inputs for the other algorithm. And also there can be supplementary software modules which help the machine learning algorithm to function. For example, in recommendation systems, there is the problem of the so-called cold start, when the system doesn't know anything about the new user, and it has to recommend some content to the user. And there can be a special module, which is not a machine learning module, but it helps the system to decide whether to use machine learning or to use other techniques when it sees the new user about which it doesn't know enough. And as I've said, the third one is the application. So adapting new known techniques, known machine learning techniques to the new area can generate inventions. And so you need to focus on those three areas to find your invention. And when you're drafting the claims, I would recommend to focus separately on the training phase and the in-use phase of the algorithm. So one independent, at least one independent claim for the training process, and one independent claim for the in-use phase, when the training with already trained algorithm is exploited. And also is, as in all software-related patent applications, I would recommend to patent it as a process and as a and as something tangible, for example, as a server configured to perform certain actions, or a machine-readable medium. So there are two recommendations: split the training phase and in-use phase, and also patent something tangible. I think briefly, this is everything I wanted to say.
Yeah, thanks, Andrey. That was very interesting. And I think, in particular, the last point that you made speaks back to something that Martin raised earlier about not necessarily trying to patent a whole system, because, as you said earlier, Martin, you can reach a stage where you have contributory infringement rather than direct infringement. So I think what you were saying there about having the server or the tangible medium separately, I think is a really important thing. Gaurav, Martin, do you have anything to add or to contribute to what Andrey's very insightful piece there?
Yeah, but you know, the issue for us practitioners, right, in the trenches, is different from you industry guys, because Andrey, if you work for Yandex, then I imagine, how many developers do you have there in the?
Well, we have around 12,000 people, and more than half of those are developers.
Yeah, so you have 6,000, and they produce about 3,000 inventions a year, or 10,000. How many?
Well, they produce a lot. We file maybe 50 to 100 per year.
Ah, okay, but then you...
I mean the first filings. We also patent.
Yeah, sure. I only talk about first filings. Yeah, but then you have to condense something from a few hundred or a few thousand down to a few hundred for filing.
Yeah,
and,
we need to filter those, yes.
Yeah, sure. And for us, it's very different because usually, I mean, the times when we worked for large companies, they are long over because this is a very competitive business. So we work usually for startups and for SMEs, but also for medium-sized companies who have a product that is linked somehow with an invention. So this is not, we don't talk about hundreds of inventions per year, but maybe about a few to a dozen. And then it's very different because these people, they wouldn't engage into developing a new black box for processing data. They wouldn't engage into, more often they would, for example, collect data from hospitals. And then easily we talk about tens of thousands of patient data that are processed with something that exists. And then there's some, I don't want to use it, but I use it because I have an artificial intelligence who does something with that data so that you can extract some other knowledge out. So I'm coming from an entirely different perspective. And for that, for us practitioners, the AI is always a black box and it depends all on the training data that you use. And then in the second step, as you have correctly said, what do we do with that data in practice? How to make money from that? And then we are always halfway in the business processes. So the problems that we face is very different from what you have because you are up in the value chain while we are down where the dollars are collected ultimately. Yeah. So, but I totally agree with you. If you don't follow these 4 basic rules, then you are gone. One thing to add, what I would like to add, what often people come to see us and they say, now I have this wonderful application with my data. Instead of the prior art patient data, I use weather data. And now, is this a patent? And the problem is the transport data never helps us in most jurisdictions on this earth to qualify for a technical invention. Most of the time we are put into some business method corner and then say, no patent for you guys over there. I mean, some countries still do, but most of them don't. And that's what I just wanted to add. Just by applying a known technology to something new, then very rarely this is something patentable. And it only becomes patentable if you dig very deep in your toolbox and find some connection on a physical signal level that has nothing to do with the transport data to overcome that hurdle. And that would be my question to the audience. What purpose are you pursuing when you file a patent? Is it to sue somebody at a later time, or is it more for, I don't know, you tell me.
Well, I mean, it could just be a whole raft of things, couldn't it? I mean, it could be for defensive purposes, offensive purposes. Then you look at, of course, the possibility of tax structures as well, where IP is held in various places. So, from a business perspective, there are so many possible uses, and it's often, I find, very difficult to be able to clearly enunciate that to outside counsel sometimes, because they just say, well, this isn't a particularly good patent, and you may be looking at it thinking, I don't really care, it's good enough to scare off a competitor, and that's all I need.
That's what I wanted to hear. Thank you.
I think if I could just take it forward myself slightly with, as many of you will be aware, the enlarged Board of Appeal of the EPO has recently settled G1 of 19, which was the computer simulation case. And I'm just going to spend a few minutes, if I may, and Martin, please do chip in with your thoughts on this. And if you can,
I was part of that,
Oh, were you?
Yeah, I was part of G1 19. I supplied one of the two basic decisions that were allegedly contradicting. Not
Was it Steinbrenner's, the 1227 of 05?
Yes.
Yeah.
I was the guy in the oral proceedings. I got whacked by these guys, and later this changed the whole manual, manual for examination.
Yes, that's actually a very interesting case to read in its entirety. So my congratulations to you on that. This was actually a referral from the Technical Board of Appeal case, which was T0489 of 14, and the case relates to the simulation of pedestrian passage through a building during the design phase of a building. And why may you think that is important? Well, what I can say is that the new lines of the London Underground were specifically built to avoid collisions between people. They have certain curves around their passageways, and there are certain projections that actually force people out to move in a certain way so as to reduce the possibility of collisions between people. And now, as Martin mentioned, this was brought about by a divergence in case law between T1227 of 05 and T453 of 91. And in the 1227 of 05 case, I'm going to paraphrase here, Martin, so forgive me for not characterizing your invention adequately. Go
ahead.
There was a 1/F noise filter that was used to remove noise from the circuit, and the claims did not actually require the circuit to be built. And it was actually the application of that filter in the appropriate way that was held to be patentable. And in T453 of 91, the Technical Board of Appeal required the building of a chip according to the design simulation to be patentable. So this referral came about, and there were three questions that were asked, and I'll paraphrase them. I'm not going to go into the full expanse of them because they're quite long, detailed questions. Effectively, can a simulation of a technical system on a computer solve a technical problem? That's a paraphrasing question one. Paraphrasing question two, if yes, what are the criteria for patentability? Is it sufficient that the technical principles of the physical system are embodied in the simulation to provide patentability? And question two, is it relevant that this case is a design process? And essentially, and I must admit, I was involved in this as well, Martin, because I was part of the EPI group that drafted the amicus curiae brief. And I watched the proceedings from the EPO live, and basically everybody wanted this to come down on the side of simulations being patentable, provided they were sufficiently technical. Even I think the EPO did, though they couldn't say it explicitly, because I think there was an understanding and a realization that not to do so was to effectively cut off a large part of very technical advances around things, for example, like digital twins. And if you're not aware what a digital twin is, it's a highly detailed computer simulation of a live system. So for example, and I'll take an example from Eaton ourselves, you could simulate the use of a jet fuel pump in a jet engine and say to Pratt & Whitney or Rolls-Royce or Airbus, by the way, you need to change this because it's likely to fail in 1,000 flying hours. And it's far better to take a jet fuel pump out earlier than have it fail mid-flight. I think we can all agree on that. So there are a number of things that came out of this decision, one of which was that the convict approach to patentability of computer implemented inventions, which is T641 of 00, if that isn't burnt into my mind, it should be, was affirmed. And what that effectively says, and again I'm paraphrasing, is that you separate out the technical and non-technical features and analyze the technical features for patentability. And if they are patentable, then the claim as a whole is patentable. That's a very quick paraphrasing of that decision. So the enlarged Board of Appeal, as legal boards of appeal that the EPL sometimes want to do, effectively said, okay, we will apply convict, which means that computer simulations can be patentable, provided that they meet the criteria for patentability that are held otherwise in convict. And what they said about T1227 of 05 was that the claim was so specifically limited, and it provided, I was going to quote here, the claim was provided such that the method is functionally limited to that technical purpose. And there's an emphasis on specific and limited purpose of the output of the claim simulation methods in G1 of 19. And they also said that only in exceptional circumstances may calculated effects be considered implied technical effects. So the upshot is that a computer simulation of a technical system or process can be, but does not necessarily per se solve a technical problem unless it goes beyond the technical effect of running the simulation on the computer. And I think the one takeaway, or my one takeaway from this decision, was that you need to look at specific features of your claim when it comes to inventive step and technical effect. Don't just have some broad implied technical effect across the breadth of the claim. When you're drafting the claim and when you're prosecuting the application, you really, really do need to think very, very carefully about the technical effect of each feature and have that in the spec and be prepared to argue that. The days of hand waving and saying, oh, well, it reduces computational power. Okay, how, where, exactly what is it that reduces the computational power?
Yes.
Which again goes to your point earlier, Martin. It's a point that I've long held when I've been drafting, and I've held my outside counsel to for a long time. And I think to the final point, that the final question, that is it relevant that this is a design process, the enlarged board held that no, it isn't. It really doesn't matter if it's a design process or a digital twin. The same rules, those of convict, apply. So ultimately, we ended up with a status quo ante, that there is no real change in practice, but it's really clarified and brought into focus the importance of these things around having specific technical effects called out and being very, very careful in your claim drafting and the content of your application, which I think we all know is important, but to have it called out in such clear terms, I think is very, very useful. And with that's me finished. Martin's nodding, so I'm hoping I've got him on side with this one, with my assessments.
Say again?
I said you're nodding, so I hope I've got you on side with this assessment.
No, I mean, Sean, you're entirely right. It ultimately, I believe, if done properly, you get a 99% rate of patent grant for software patents, but only if you do it right. The problem is that you guys all are caught between a rock and a hard stone, which means a budget, and that would limit everything, right? If you have an unlimited budget, fine, you don't. So how to do well without resources? I cannot answer that, because I remember coming from a programmer background. When I started as a patent attorney, I had a very old partner, Hans Reible from Stuttgart, and he told me the same thing that I told you now, 28 years later. If you give me budget, I get the patent for you, but it must be done before we file. If you all the effort that you invest after filing is only the outcome of not investing before filing. That's the main problem. Number two, what I would like to add, the Convic and the Infineon, the 122705, they are not contradicting each other. I put the link into the chat, And that link goes back to an article that I've written a short time after someone else, an Austrian colleague who attended the oral proceedings, has written some aide-mémoire, some minutes about what he saw, because I was there. And this thing, the oral proceeding went only half the way, right? And then they withdrew, and then they discussed, I don't know where, hopefully in a restaurant. And so we knew nothing. But what he has written up gave me all brought back what was there. And then the decision, if you read the decision, they carefully focus on evaluating the case law before, rather than saying what is now going on with that specific simulation patent. And a third aspect is the G190, the T122705 is very often misinterpreted. It's not about whether a simulation is patentable or not. When I went into the oral proceedings, the whole board, I mean, these guys, they were all on my side, and then they let me play, right? I was a very young patent attorney at that time, barely 30 years old. And I came with my request, and the auxiliary request, and the next auxiliary request, and I said, oh, boy, now it's time for lunch. Here are our claims. This is what we want. And then I looked at that, right? And then the representative of the client was there. We looked at each other and said, okay, we take it. And then we go for lunch. And then this is how the T122705.
Infineon, yeah.
The Infineon was done. And ultimately, the only problem they had was the algorithm was patentable because it reduced the amount of memory used for the simulating these random numbers, and you could for the first time do an online add-on further random numbers to the series that was already there. Before you had always a fixed number of series, and then this was the first one. So yeah, we believe you, but we have a problem because you have written that you can simulate stock markets. 2001, right? We had the .com bubble. And no, we don't give you a patent for a business method. And I said, okay, but you need to limit this to simulating a semiconductor. And then you are not within the business method patents, but only in the technical patents. And I did so. And later I found out that everybody thought, now, oh, we simulate a technical system and suddenly we are technical and we get a patent.
Yeah.
And that went on for 20 years until G119. And I was always sitting there, and people never knew about what they're talking, and they thought, yeah, we have a simulation, it's technical and blah, blah, blah. Simulating is only transport data, and transport data doesn't make your algorithm patentable.
Agreed entirely. Yeah, that is exactly my take on the whole simulation piece, unless there was a technical effect. And yeah, no, I agree. I have to say, I agree with you. There is no. I've never thought there was a contradiction between Convic and Infineon, because there was clearly a technical effect associated with Infineon. Okay, excellent.
Yeah, Gaurav, tell us about the Bajaj software patents.
Well, while Gaurav is joining, I would like to add my 2 cents about patenting software in with the EPO. We did have some experience with the EPO, and I would it's very difficult for me to agree with Martin that 99% of the inventions can be patented in the EPO with the EPO. In our traditional areas like internet search, content recommendation, and information retrieval, and so on, the EPO is adamant in their position that those are not technical. They constantly said that those are cognitive effects. So even if there's a huge technology with a lot of science going on that makes it possible to provide users with more relevant search results, and this relevance can be measured mathematically, they still didn't want to grant patents. So actually, after several years of struggling in those areas, let's say it could be not just information retrieval, but voice recognition or natural language processing, which is also very technical. Well, from my perspective, very technical. There's a lot of science there. There's methods how to process sound waves and so on. We struggled there, and at some point, for many products, we gave up because it was too expensive to patent there. And government fees are huge in the EPO, and the outcome was very small. So we concentrated on more technical, well, presumably more technical areas. And we have better experience when the software is used to operate something tangible. Let's say in self-driving cars, this area is going more smoothly for us than let's say internet search.
I think I'd like just make a couple of comments about that, if I may, Andrey. I think I agree with you that the areas that you're dealing with there are more difficult, because I've spent 6.5 years as MasterCard's lead IP counsel outside the US, so I understand. I mean, we for some reason we even had a problem with one application around cryptography, which I never actually got my head around why that was an issue, but we got it in the end. But what I would say is that, and being candid, a lot of that I think comes down to the original drafting and the tack of the application and the content and how it's framed. I think to Martin's point around the business method in the Infineon business method objection in the Infineon case, I think if you frame the application in a technical way sufficiently and then have sufficient technical information in there, it should, I would hope, be patentable in the EPO. Your thoughts, Martin?
Yeah, I fully agree. And I'm still with the 99%. The problem is if you don't include this, and maybe the second, you need an inventor or patent attorney, because you need to be creative. You cannot draft a software patent application with a sufficiently good chance of getting granted without being creative. It doesn't work. It doesn't. So if you have a system where you say, okay, we give you so many patent applications per year, we pay you that amount, please deliver your applications. Of course, would we do that, right? But don't you think that this works for software patent? At least 30%, if not 50%, will not be granted because we don't have the budget to provide a decently drafted patent for that. It's not possible. And then, I know what to do. Maybe split the patent applications in half and find out what can be done. That might be something. Focus on those that you can afford to pay a decent drafter to do it. I believe if you fail with your software patent application, it's a failure of the guy who drafted the patent.
I would say not always. I would candidly say not always. I think I'm halfway between yourself and Andrey on that one. I think that there are some that just won't get through whatever. But I think ultimately, I think that you could probably get more than you got, Andrey. I think is my thought from what you're saying about the subject areas.
I may add, and if it's a failure because you didn't dare to say no, I don't draft this.
Yeah, that's true as well. Yeah, that's actually true. I think we're actually out of time, and unfortunately, Gaurav hasn't made it back in.
Yeah, we wait for the Bajaj patent. Actually, Bajaj is quite an impressive company. It's from India, and is the largest car manufacturer in the world, correct?
I'm not sure. I think that we're up against time, I believe, aren't we? Because we had 40 minutes from 5T, so unfortunately, it looks like we're out of time.
In the meanwhile, we have a question from Nirupam on the chat box. If anyone would like to take it, that I hear a lot of comments on. Sean, if you can read that.
I have a lot of comments on simulating a real-world scenario on software digital twin, and would like some more discussion around software implemented invention such as AI writing a book, who will be owning the copyright, and is such an innovation patentable? I think the copyright position, certainly in the UK and Ireland, is fairly settled. That the copyright would be by the person who put in place the AI software to write the book. That's actually settled, and that's in statute. Is such an innovation patentable in terms of an AI writing a book? I'll pass that one to you, Martin, because I know from you the answer is yes.
No, please, no religious discussion today. You know, I come when it comes to AI. My position is very simple because I'm a believer in God. So I believe in creation. I believe in something that is, and we are special. We humans. I never believed that humans could build a machine that is smarter than humans, because we don't even understand our own intelligence over the thousands of years. And then there is this group. There was this crackpot. Now he was a chief engineer of Google or something. I don't know. And then he got a jail sentence for stealing trade secrets. And he was the one who created the Church of AI. And then he collected people around him, and then they said, yeah, we will create robots and computers that can program computers, and then they become like humans and even more powerful because they're faster and know more. And then I said, sorry, I'm out. I'm a patent attorney. I try to help my people make business and produce money from ideas, but I don't engage into these crackpot discussions. And yeah, I'm not into that. No.
Okay. Well, I think we're slightly over time at this point, so I'd like to thank Andrey, Martin, and Gaurav, who unfortunately we ran out of time because of his laptop issues, which is a pity, because I was looking forward to hear him speak about Indian patent practice, because it's an area that we have a lot of software engineers in, and certainly it's a very important area.
In the meanwhile, the participants, do we have any more questions for these speakers? So they can write down on the chat box on the right, or come face to face, speak to them and ask their questions directly. In the meanwhile, let's have a quick smiley screenshot together and take all the memories along with Sean, Martin, and Andrey. All right. Thank you so much.
Thank you.
Thanks very much indeed.
Bye.
Bye, guys. Thanks.
See you all.
Thanks.
Thanks.
Thank you.
Bye.
Bye-bye.